I was walking through the supermarket yesterday, just aiming for the cereal aisle, minding my own business, and I had this sudden realization.
Oh,
I wasn't looking at food, I wasn't looking at boxes, I was walking through a minefield of legal property.
that is a very dramatic way to look at breakfast,
Uh,
but you are not wrong.
No, seriously. Every logo, every specific shade of orange, every catchy name, every font choice, it is all someone's territory. We
Yeah.
take it for granted because it's just the background noise of modern life. But have you ever stopped to actually think about the mechanics of how you claim a word?
Go on.
Like, how do you reach into the dictionary, pull out a word that belongs to everyone, draw a circle around it, and say, this is mine, you can't touch it?
It is a wild concept when you really drill down into it. You're taking something from the public commons language and converting it into private property.
Ex-
That transition from word to trademark is the bedrock of modern commerce. But what is interesting is that while we often talk about what a brand is, the marketing side, the vibes, the emotional connection, we rarely talk about the how.
The actual legal
The legal
machinery.
machinery that makes that ownership real.
And that is exactly what we are doing today. We are looking under the hood. We aren't just admiring the Apples and Nikes of the world. We are doing a deep dive into the procedural intricacies, and I love that phrase, procedural intricacies of obtaining a trademark registration.
Right.
Specifically, we are looking at the roadmap provided by Indian law under the Trademarks Act of 1999, and we're basing this on a lecture by Mr. Ashini Seal from Delhi University.
Right. And for anyone listening, don't tune out just because we said law or act. I mean, if you were building something, whether it's a tech startup, a coffee shop, or even a personal brand, you need to understand this.
It's fundamental.
It is, because while marketing builds the reputation, the legal side, what we call trademark prosecution, is what secures the value.
Prosecution. I want to pause on that word because it sounds so intense. It sounds like we're sending someone to jail. I am prosecuting this trademark.
It does sound dramatic, doesn't it? But in the world of intellectual property, prosecution doesn't mean a criminal trial.
Okay, good.
It refers to the administrative and legal process of moving an application forward. You are, in essence, prosecuting the case for your registration.
So you're arguing for it.
You're pushing your application through the hurdles of the trademark registry. You're answering objections, fighting off challenges, until you hopefully get that certificate.
So it's a gauntlet.
It is absolutely a gauntlet. It's not just filling out a form and waiting for a sticker. It is a legal journey.
Okay, so our mission today is to map out this hurdle race. We want to take the listener
After all-
from that moment they have a cool idea for a name all the way to the moment they hold the registration certificate. But before I get to the forms and the fees, the source material throws a curveball right at the start. It basically says everything I thought I knew about registration is wrong.
You are referring to the myth of mandatory registration.
Exactly. I always assumed, and I think most people assume, that if I don't register my logo, I don't own it. I thought registration was the thing that gave me the right to use the name.
And that's a huge misconception.
But the source says that's not true.
It's not. In India, and generally in common law systems, registration is not mandatory. The law is actually quite permissive.
Really?
You can start a business today. You can call it the Deep Dive Cafe. You can paint a sign, print some menus, and start selling lattes. You are using the trademark.
Just by using.
Just by virtue of using it. You have rights. You are a proprietor of that mark.
So wait, if I can use the name and I have rights without doing any of the paperwork, why on earth would I bother with the bureaucracy? Why pay the government fees? Why hire a lawyer?
Because not all rights are created equal. This is the difference between bringing a pocket knife to a gunfight. If you use a mark without registering it, your rights come from what's called common law. If someone copies you, say a guy opens the Deep Dive coffee shop right next door, your only legal remedy is to sue them for passing off.
Passing off. That sounds exactly like what it is. They are passing their goods off as mine.
That is exactly what it is. But here's the catch. Passing off is incredibly hard to prove. The burden of proof is entirely on you. You have to prove you have a reputation, which hard if you're new.
Yeah.
You have to prove the other guy is intentionally deceiving the public. You have to prove you suffered financial damages.
That sounds like a nightmare.
It involves bringing in witnesses, showing sales figures, proving market confusion. It is messy, it is expensive, and it is uncertain.
Okay, that sounds like hard mode. So what does registration give me? What's easy mode?
Registration changes the game completely. Under the Trademarks Act of 1999, specifically looking at Sections 27 and 29, registration gives you a statutory right.
Statutory right. Let's unpack that. What does that mean in practice?
It means the statute, the written law explicitly says, you own this. You don't sue for passing off, you sue for infringement.
And the difference in the courtroom is?
It's night and day. In an infringement suit, you don't need to prove you're famous. You don't need to prove the other guy is tricking people. You don't need to bring customers to testify they were confused.
So what do?
You basically just walk in, wave your registration certificate, and say, Your Honor, I own this mark. Here is the government document proving it. He is using it. Make him stop.
Wow.
The certificate is conclusive evidence of your validity.
That is a much sharper sword.
It is. It shifts the power dynamic entirely. Registration presumes you are the owner. Non-registration means you have to prove you are the owner every single time.
Okay, I'm sold. I want the sharp sword. I want the statutory right. But this leads us to another weird quirk in the source material that I found fascinating. I'm calling it the Lux paradox.
Ah, yes. The soap and the underwear.
It sounds like a bad comedy sketch. But seriously, we all know Lux soap. Unilever, huge global brand.
Classic.
But the source points out that there is also a registered trademark for Lux for underwear owned by a completely different company. How is that legal?
Right.
I thought the whole point of a trademark was exclusivity. If I own Lux, shouldn't I own it everywhere?
You would think so, but that's not how the system works. You don't own the word Lux in a vacuum. You don't own it in the entire universe.
Okay.
You own it in relation to specific goods or services. The trademark system follows something called the NICE classification.
The NICE classification, is that because it's polite?
No, it's named after the city of Nice in France, where the agreement was signed. It divides all possible goods and services into 45 classes.
45? That's a lot of buckets.
That covers everything. Classes 1 through 34 are for goods, physical things you can, drop on your foot. Chemicals, paint, soap, machinery, vehicles.
Right.
Classes 35 through 45 are for services, banking, education, running a coffee shop, software development.
So going back to the paradox, soap is in one class.
Soap is in class 3.
And underwear.
Clothing is class 25. The legal logic here is based on consumer psychology. The law asks, is a person who buys a bar of soap likely to accidentally buy a pair of vests, thinking they came from the same factory?
Probably not, unless it's a very strange soapy vest.
Exactly, because the goods are so different, there is no consumer confusion. Therefore, the law allows identical names to coexist in different lanes.
That's why I can have Delta Airlines and Delta Faucet.
Perfect example. Same name, totally different classes, totally different owners. No one is trying to book a flight on their kitchen sink.
This adds a huge layer of strategy to the process, doesn't it?
Oh, absolutely.
If I want to be the king of deep dive and I want to create a lifestyle brand where I sell podcasts and t-shirts and coffee mugs and maybe energy drinks, I can't just file one form and be done.
You can, but you need to be deliberate about it. You need to identify which classes you are playing in.
So my podcast is one class.
That would be Class 41 for education and entertainment. But if you register only in Class 41 and someone else registers the deep dive in Class 32 for energy drinks, they can legally do that.
So if I want to own the empire, I need to block those classes.
Precisely. You can own the mark across all 45 classes if you have the budget and the justification for it, but you have to pay separate fees for each class. So usually businesses pick the core classes relevant to them.
That makes sense. It's about staking your claim where it matters.
Okay, so we know why we register to get that statutory weapon. We know what we're registering a mark in a specific class. Now let's get into the actual procedure. Mr. Sile uses a framework in the lecture that I really like, the 4 quadrants.
It is a very useful mental model. Legal processes can feel like a tangled ball of yarn.
Definitely.
The 4 quadrants, who, when, how, and where, untangle that ball. It turns the act into a checklist.
Let's start with quadrant 1, the who. Who is allowed to file for a trademark? Do I need to be a corporation? Do I need to be a citizen? Not at all. The legal term is proprietor, and the definition is extremely broad. You can be an individual, you can be a partnership firm, you could be a private limited company.
So